If it pleases the court, my name is Groth, initial M. I am a senior counsel on behalf of the defendant Papa in this matter today. Your Honour, counsel submits two issues in response to the plaintiff's submissions. First, that So Snooty Inc. is liable under Section 18 of the Australian Consumer Law, Schedule 2 of the Competition Consumer Act 2010 for deceptive or misleading conduct in failing to inform the defendant of the height of the lot. And secondly, that So Snooty Inc. should be estopped from denying payment to the fit-out costs to the defendant. If it pleases the court, I will now proceed with submission 1. Your Honour, we know that pursuant to Section 18 of the ACL, a person must not engage in conduct that is misleading or deceptive or likely to mislead or deceive. We know that given the parties of both companies, the definition of person pursuant to Section 4.1 of the CCA has been satisfied. We also know that there has been conduct between the parties. This is a matter of fact to the case at hand. What remains in question is what that conduct amounts to. Your Honour, strong common law authority exists for cases of this nature. In particular, Form and Barport 218 VSC 291 asserts similar circumstances where there was a dispute over the heights of a lot, and the matters of deceptive or misleading conduct was referred to in detail. Now, whilst counsel acknowledges that in this case it was found that misleading or deceptive conduct was not held, there are important considerations raised relevant to today's case. Firstly, in paragraph 115 of the form, reference was brought to the starting point found that the significance of silence depends on the circumstance of the case. Also, in paragraph 116 of the form, the court observed that in the event a reasonable expectation may arise, the failure to disclose a fact may give rise to misleading or deceptive conduct. As such, it is important to consider the current circumstance with regards to what the parameters of a reasonable expectation may be. The parameters of what a reasonable expectation was considered in the case of Miller and Associates Insurance, Booking Pty Ltd, and BMW Australian Finance Ltd, 2010-241 CLR 357. Namely, the characterizations of conduct, silence, the knowledge of the persons to whom the conduct was directed to, and the common assumptions held between the parties. Further, the case of Henjo Investments Pty Ltd and Collins Marrickville Pty Ltd 1988 found that it is no defense to say that the person should have made their inquiries, and if they had have made their inquiries, that the truth would have been discovered. This failure does not in itself negate the duty to disclose. Your Honour, the claim in Baum for misleading or deceptive conduct ultimately failed for a number of reasons different to that of the current case. Firstly, it was held that the claim brought in by Barport was improperly pleaded, as Barport was not one of the initial contracting members to the initial contract. This is not the case here, so Snooty and Papa are both initial contracting members. Secondly, it was held in Baum that the failure was determinative despite the principles formed in Henjo, as the statement was read in light of authority found in Miller. Your Honour, we assert that unlike Baum, the failure of Papa to make inquiries was not so severe as to amount to a careless disregard of his own interests. We refer back to the parameters as set out in Miller itself. There was a common assumption held between the parties. Papa had no experience or expertise in the knowledge of constructing hangars, and silence to disclose was a vital fact which caused detriment to Papa. Your Honour, in conclusion, we acknowledge that while strong authority does exist in cases of this nature, we respectfully request consideration given to the current factual matrix, and that So Snooty be held liable under Section 18 of the ACL. If Your Honour has no further questions, I'll now proceed with submission 2. Your Honour, So Snooty Inc. should be estopped from denying payments to the fit-out costs to the defendant. The leading case for this matter is Walthamstone's Interstate Ltd and Mayer, 1988, HCA 7. As per Justice Brennan, at paragraph 428 to 49, the rules of equitable estoppel were outlined. Namely, the plaintiff assumed or expected that a particular legal relationship existed between them and the other party, and that the other party would not be free to withdraw from this relationship. The defendant induced the plaintiff to adopt the assumption. The plaintiff act or abstains upon that assumption. The plaintiff's actions or inaction will occasion detriment if the assumption or expectation is fulfilled, and the defendant failed to avoid the detriment. Further, in accordance with the case Legion and Hately 1983 HCA 11, in such circumstances, the promise must be clear and unambiguous. Your Honour, it is our assertion that these elements are met and satisfied, and the promise was clear and unambiguous. First, in Waltons, the negotiations were commercial in nature, of a lease, demolition and construction of a building to set specifications. Likewise, for the case at present, the commercial nature of the negotiations, in conjunction with the costs surrounding the fit-out process, satisfies this first element. It is also reasonable to assume that Papa was under the expectation that legal relations had arisen, and that society was not free to simply withdraw from such relations. Second, Walton Store had issued a tight schedule for demolition and construction, with instructions from Walton's solicitor that approval was forthcoming. This ultimately induced Mr. Mayer in proceeding. Likewise, the email drafted on the 4th of June stipulates that Society would fix up the fit-out costs for the concession, and that she would be prepared to be more than generous. Further, the initial quotes of $23,000 to $39,000 were ascertained by Papa, which were relayed by way of email to Society, in which she responded stating she would have paid $50,000 and that Papa need not worry about ascertaining more fit-out costs, as she would, in her words, fix up Papa come fit-out time. Third, Mr. Mayer acted on this inducement. Likewise, Papa proceeded with the fit-out costs. In reliance to the guarantee given by Society, there was no requirement for him to gain further quotes or to consider the fit-out costs as per Society's instruction. Fourth, Walton stood by knowing Mr. Mayer was proceeding with the demolition in reliance of the purported contract. Likewise, Society was well aware that the construction of the fit-out had begun, and in no way informed Papa of a change of intentions, even after seeking legal advice prior to the completion of the fit-out on the 13th of December. Fifth, Mr. Mayer was left with a demolished building and a 40% complete new building according to Walton's expectations, which Walton had not avoided. Likewise, Papa had initially only intended to operate the concession within the hangar. It was Society who desired the extension of the concession to the airstrip. Papa only acted on the guarantee given by Society in extending this concession, which resulted in an extra $11,000 as per the food and safety regulations. Your Honour, there is condemning authority found in Crown Melbourne Limited and Cosmopolitan Hotel, Vic, Pty Ltd 2016 HCA 26, where it was held that the tenants did not act on the basis of an expectation, namely that the tenants would have been offered a further 5 years renewal. As such, there was no estoppel found. However, Your Honour, it is our submission, as per previously addressed points, that this authority does not apply to the facts at present, and that the 5 elements of equitable estoppel has been satisfied. As such, Counsel respectfully requests Society be stowed from denying payments for fit-out. Your Honour, if there are no further questions, we respectfully request the Court consider our submission for today's matter. Thank you.